Play our music.
Yeah.
I'm gonna say, how will they even know that we're coming on the air without that intro of the music?
They'll hear you.
Got
Your dulcet tones,
Oh,
Laura.
got it. So did Ann Curry announce she's not going to be co-anchor?
It was tearful.
Did you?
It was tearful.
Okay, because she had announced by the time I walked out of the room.
Oh,
and
you
so
missed it.
8 o'clock is when I walked
Well,
out.
you too, but
I'll have to. I'm devastated. Who's going to take her place, did they say?
I didn't hear. But I saw them all crying on the sofa.
She's staying there, though. I mean, she's going to head 7 people on assignments or something. Foreign assignments.
Yeah.
They're sending her
And
overseas.
she's walking away with $10 million.
Well,
What the heck? Yeah.
Not a bad deal.
so I assume
Not a
those
bad
were
deal
happy
for a year,
tears.
right?
Huh?
I assume those were happy tears.
Well, they weren't today, but they will be tomorrow.
That's
When
right.
she starts spending that $10 million.
Jeez.
Laura, you going to talk about real estate this
Well,
morning?
no, this is a lifestyle
Yeah,
show, and if you
right.
haven't gotten that, then maybe I have the wrong co-host.
I'm a lawyer and I have no lifestyle, so.
Well, there you go. So anyhow,
Bill
here we
Schlechte,
are.
by the way.
Bill Schlechte, Laura Schlechte, Jackie Austin, Family Affair.
And
going on
I've
here.
become guest emeritus, I think, is what's happened on this show.
Guest emeritus.
Yeah.
I like that.
Right. That's because we put Mark. Mark is now with 7 people over on foreign countries.
Doing foreign assignments.
Except for it's probably just foreign roads because he's staying local here. So anyhow,
Yeah, that was tearful too.
it was
Yeah.
very sad.
You had to send Marco overseas.
Well, he's just over the county line or something. I don't know.
Did you say tearful or cheerful?
He's
I
over the
said
township.
tearful.
He's over the township lines because he's
Okay.
still in Jackson
He
County.
doesn't even call anymore.
He probably will.
All right.
Well, I'll have to ask him if he's listening.
All right, so Laura, you want to talk about the subject that you asked we talk about this morning? Is that the
I
plan here?
have no idea. So if you have any questions, though, if
Sure.
anybody
Call.
wants to call in, do you know what the number is, Bill?
No clue.
787-3397 is the phone number. So if you have any questions, 787-3397. And if for some reason you know someone who's missed this show, you can always go to our website at 780-3800.com and watch it later. Share it, Facebook it, forward it.
ThinkingRealEstate.com.
Thinking Real Estate. Or thinkingrealestate.com. We have many website names. So,
What was the topic, Bill?
Laura, we've talked about this before, and the problems that arise with
In your
respect
production
to title
meeting?
insurance. Yeah, in the pre-production meeting.
Yeah.
Yeah, that was the drive out here this morning. But again, there's so many things that we could talk about. I had suggested to Laura we might want to at some point talk about wetlands and inland lakes and streams because there's so much water around here, lakes, streams, rivers, etc. Talk about surveys, talk about boundary issues. I mean, I've done hundreds and hundreds of boundary disputes over the years, but we thought maybe the thing to talk about this morning might be title insurance and some of the limitations of title insurance when a buyer gets an owner's policy of title insurance, the fact that it has what are called the standard exceptions. There are 3 basic or standard exceptions. One would be rights of parties in possession. That would be like neighbors who have an adverse possession claim or neighbors who claim an easement by prescription across the property. Second exception, standard exception, would be construction liens not of record, and we can talk about that in a future show because that's a topic in and of itself. And then the third one is what's known as a survey exception, those things that would be disclosed by an accurate survey. And when I say accurate survey, I mean a boundary survey and not what most people get, which is a mortgage report. And we can talk about the differences between those two.
however, one survey doesn't mean that another survey is going to match it.
Well, that's a whole different issue on how a survey is done and what kind of judgment calls are made in the field. So can we save that one for another day
Maybe,
too? Because
Maybe we'll segue into that. This is not a pre-planned show here.
Anyway,
We like free flow.
dealing with the title insurance, the first 2 exceptions are easy to remove by virtue of an affidavit from the owner of the property. The owner certifies under oath to the title insurance company that there are no adverse possession claims or claims of parties in possession other than the owner, and then construction liens not of record. They simply verify again under oath that no construction or improvements have been done within the previous 90 days.
Similar to the one we just closed on this week.
Yeah, Yeah, and we can talk about the closing this week. That was through American Title, and we worked with American to get certain title issues resolved.
And I always say a happy title company is a happy closing.
Oh, really?
I don't think I
If the
ever
ti-
said that, but it,
I always say that, because if
Yeah.
the title company's happy, then it can move forward.
yeah, I mean, you got to satisfy the title company, but the purchaser has a real interest in making certain that the title company is satisfied, because if the title company isn't satisfied, then they won't issue the policy of title insurance,
Right.
which provides insurance or insuring marketable title in the purchaser. So getting back to the survey exception, that's the one that the title company is not going to remove without a survey. Now, if the property is in a platted subdivision, the improvements have been there for a long time, the title company might accept a mortgage report, not called a mortgage survey, but a mortgage report. But all that does is verify that the improvements on the land lie within the boundaries. It's not a boundary survey. There's
I
a big
haven't
difference
had a-
between that and a boundary survey.
I haven't had a title company require a survey on a subdivision lot.
Yeah,
For-
well, as I say, if it's in
for
a
without
platted, if
exceptions.
it's in a platted subdivision, been of long-standing duration, you maybe get away with a mortgage report. However, if you don't fall within that, and I call it limited circumstance, the title company is going to require a boundary survey, an ALTA, American Land Title Association survey that meets minimum requirements, fairly expensive to get on a lot of properties. And most purchasers will not pop for the cost. Sellers almost never pop for the cost, so it's going to be the purchaser's choice. And if the purchaser doesn't get that survey and the title insurance company is unwilling to remove the survey exception, the purchaser must understand that later on, if there is a dispute with a neighbor over where the exact location of boundary is, the title insurance will not cover that dispute, and the purchaser will be on their own in terms of litigating where that property line lies. And people think that the boundary is the boundary is the boundary. That just is not the case.
What about adverse possession?
Adverse possession changes a boundary by operation of law. If I possess the property of another openly and notoriously under a claim of right, claiming it as my own, without the permission of the legal title holder, and I do so exclusively for the statutory period, which is 15 years, by operation of law, I become the owner of that property. And it doesn't require me filing a lawsuit, doesn't require any other action, it's by operation of law. I might have to file a lawsuit to get a judgment on record decreeing that that's where the boundary is, but we do still have in Michigan this concept called adverse possession, which, if a neighbor encroaches on the adjoining boundary, they might acquire that title. The same thing is true of another legal doctrine called acquiescence. Acquiescence, there are three different kinds. The most common kind is where two property owners, adjoining property owners, agree upon the location of a boundary, even though it's not the surveyed boundary line, but they agree upon it for a period of the statutory period of 15 years. Doesn't have to be adverse to the adjoining property owner's interest. They simply have acquiesced. They've treated it as their boundary for 15 years. So that changes what the survey boundary is. And you just said
So that becomes the boundary?
that becomes a boundary. And again, I've done, as I say, hundreds and hundreds of disputes, boundary disputes involving adverse possession, involving acquiescence, or involving disputing surveys. I can have two surveyors, each coming from different points geographically, and you'll get to the center, and you'll either have overlaps or you'll have what's known as a GORE, G-O-R-E. And those typically arise from either the curvature of the earth, as you move northward, lines converge, or they often occur because of the imperfections in laying out subdivisions or other boundary lines years ago. The techniques being used at that time were not as accurate. We didn't care as much in those days, in the 1920s, etc. So you get disputing surveys too.
Like cash changing hands there?
No, not like cash changing hands. Just really what I'm talking about is I just finished a dispute 6 or 7 months ago down in Hillsdale County, where we actually ended up with two different surveyors, both qualified, competent, experienced surveyors, but we end up with a disparity in where that line exists. So they're both right in a sense, and the problem arose from laying out this subdivision back in think it was the 19-teens or the 1920s.
Mhm.
So,
You taking calls, Bill?
sure. or-
Good morning.
Hey, Bill,
Yeah.
I have a question. On the front of our property, we have, when you talk about the survey, we have a stake in the ground that has an orange cap that's printed. Would that be considered a mortgage survey, or is that an actual land survey?
Yeah, that's going to be a land survey. That's a surveyor's stake. It's got the cap on top of it. It should be stamped with a date and the initials of the surveyor, so it's identifiable as a survey stake. You can go to that surveying company, and if that surveying company is not around, I am virtually certain, gave the records of that survey to a surveyor that's still in business, and that surveyor will be able to tell you what that stake represents. There could also be a recorded survey, and you could go to the Register of Deeds, or it may show up in your title policy that survey itself was recorded. But that would presumably be a survey stake.
Okay, and so if I needed to get that checked on, find out the exact measurements in my property, because I did for quite some time, I was cutting the neighbor's lawn, and then I didn't realize what I was doing, so I pulled a tape and went off my paperwork that I had, and I realized he's right. I was cutting this poor guy's lawn all the time. So, it hadn't been that long, but I had to go and apologize to him for doing that. I apologize. I didn't realize it was in your land. But on the other side, I don't have a stake, so I really didn't know where where my actual boundary was. We just always went by that tree, your side, this side's mine.
Yeah, well, your neighbor ought to be happy, because in Michigan, simply mowing another person's lawn does not constitute adverse possession of that property. So we already have case law on that. So your neighbor ought to be thanking you because you were doing him a favor. In terms of locating the
Will you
actual
mow my
boundaries-
lawn? We got lots of lawns for you to mow.
If you want to know where the line is, though, you need to hire a certified surveyor, registered surveyor in the state of Michigan. Have them come on out, and they'll actually physically locate the boundaries. And you need what's called a stakes in place survey. Simply getting a boundary survey, it'll show on a map. Stakes in place survey, they'll actually put in the iron stakes so that you can see where your boundary line is on the ground.
Okay. All right. Well, thanks, Bill.
Thank you.
bet. All right. What's next, Laura? What else you want to know about surveys?
What do you do about a gore? We had a piece of property where we had a gore, didn't we?
We did, and gores, typically you end up in...
So it was a triangle that didn't, according to the two surveys.
What's a gore?
If you know anything about dressmaking, you'll know what a gore
I don't.
is, because if you're doing a skirt at the top, at the waist, it comes to a point.
Do you
and
know about
as you go
dressmaking?
farther down the leg, it expands. So it's a triangular piece of ground that is what we call no man's land.
Right.
It's not owned by anybody.
Oh.
And it typically arises because of the curvature of the earth as you move northward. And so the gore ends up being contested in litigation over who actually physically occupied it for the last at least 15 years.
But what if it's in a wetlands area that no one's occupying it because you can't really get to it?
Then nobody owns it. Literally nobody owns it. It's property that is still either under it's actually owned by the state of Michigan, because when the U.S. land patent was given, when Michigan became a state in 1836, when it became a state, the patented lands were conveyed to the state of Michigan. So it may be that little gore is still owned by the state. Or if the entire section was conveyed out, it may be owned by whoever received the title to that section from either the U.S. government or from the state of Michigan back in the 1800s. So it may still be owned by that person. You don't know. You'd have to trace the history of that entire piece way back to the
And
initial
if you
grant.
wanted to claim it, what do you do? Include it in your deed and quitclaim deed it and see if there's any disputes in the next 15 years?
You could quitclaim deed it. You'd never give a warranty deed to it, simply because you're warranting title to land that you don't necessarily own. So yeah, you could give a quitclaim to it with the purchaser understanding that, hey, if there is a title issue, you can't go back against the seller.
What makes a title company, you said they're happy. What makes them unhappy?
I'll take the deal we did
Well, we just closed one
Monday or
in
Tuesday.
escrow on Monday, where Grandma and Grandpa sold the house to their kids.
Back
but-
in 1953, I think it was.
Something, yeah. Grandma and Grandpa built the house.
In the 20s.
raised their kids there, sold it to one of the
One of the sons.
One of the sons out of 4 or 5 or something. But that deed
They sold on land contract. Payments were made on land contract.
was never.
There's no copy of the land contract anywhere. There's no copy of the deed pursuant to the land contract. So title still showed up in the estate of the grandmother.
Grandparents.
It actually showed up in the estate of the grandmother. The grandfather died first by right of survivorship. The grandmother then got the property as the surviving widow. So it still showed up in her name, even though all of this stuff had been done over the last, or since the last 60 years. So we had to go to the title company, and we worked with American Title and Ron Ellison over there to work out an ability of the title company to insure title in the purchaser without the necessity of trying to open up the estate of the grandmother who died years and years and years ago. We crafted an affidavit under the 40-year Marketable Title Act, got 3 people to sign it, 2 interested parties as sellers, and then a disinterested third party who had no interest in the property, but is an aunt who was familiar with the transaction, the land contract and the deed. Voila,
And that
get
was.
the affidavit signed and we're done.
But the title company, Ron Ellison, had said what would satisfy, what would make him happy. So he
So
gave
that
us,
made him happy?
He gave us 2 options.
Okay,
That was one of the
It's
2.
easy to make him happy, actually. He's just that kind of guy.
I understand that.
He's an easygoing guy.
But yeah, and then the other thing is because this arose close to the closing, we couldn't actually get the closing done. So what we did was do an escrow agreement in which the title company is holding on to the money, holding on to the documents. Once it gets the affidavit signed by both owners, one's out in Connecticut, one's here in Michigan, the disinterested third parties here in Michigan, once they've all signed, the original affidavit is given to the title company, they'll break escrow, funds will go to the seller, deed gets recorded, now the property's transferred. So that's simply doing it in escrow.
Now, if you need a real estate attorney, it sounds like Bill knows what he's talking about. His office is in Ann Arbor, but you must do work around here?
I have a Jackson office.
Oh, do you?
Yeah, I do. It's 761 West Michigan Ave. It's the same building that Laura's in. And
Isn't that convenient?
That's not a
It's
surprise.
almost like we're together all the
But-
time.
But I've been doing it for 40 years. I've been doing real property law for 40 years. And we actually do stuff pretty much all over the state, simply because of the unusual,
The special
peculiar kinds of problems that we deal with.
So we have some new listings,
Yeah,
or I have some new listings.
County Farm Road.
County Farm Road is not a new listing, it's an open house,
Oh,
however, and
yeah.
the price has dropped down to $129,900. So that's an awesome house. The open house is 1 to 2:30 this weekend, and or Sunday, and that's Western Schools. 3 bedrooms, 1.5 baths, and a huge, all capital letters, huge family room. Let me tell you.
Large deck.
Large deck. You know it, 1
Yeah.
acre. There's an extra outbuilding that can hold 3 or 4 cars. It's a very cool house. So come and buy that on Sunday between 1 to 2:30. Other new listings, I got 6122 Kennedy Road. It's 55 acres. 2 bedroom, 1 bath house. Nothing really special about the house, but it sits on some beautiful land. $249,900, and it's a good basic house to start with a huge pole barn. And then 11940 North Lakeside, that's lake access to Lake Leanne, 164.9, 3 bedrooms, 2 baths, full walkout basement. Newer home, it's a very nice place. And then 413 North Bloomfield Boulevard, 38.5. That's a great little clean house, corner lot, 3 bedrooms, 1 bath, just move-in ready. So come and buy those houses.
There you go. More information at
780-3800 or thinkingrealestate.com.